are actually the same. We have looked at the Africa Competition Protocol. We have realized that there is issue. They are bringing economic dependency. That is the only thing which is not in our law. The rest, actually, of these issues, apart from the wordings, the generic nature of those ones, they are in our laws. One thing which we have done is that we had actually developed some poison paper on the strategic economic position, and having taken into account that now this matter has now been actually embedded in the continental law, and there's a need under Article 12 that there should be some kind of harmony between the national, regional, and continental laws. We have actually made some proposal, and actually that one has been forwarded to the National Treasury for their consideration. That as we amend our law, we also introduce provisions which relate to strategic market position. We are using different wordings, but it is basically the same concept, and the approach is the same. So our preparation has been that even in terms of the market definition, we actually have been in the process of reviewing our market definition guidelines because of the nature of the digital markets, which actually they know no boundary. So we are actually trying to amend our guideline, market definition guideline, so that it is not defined in a static way where it is only reflecting on Kenya, but it should be actually guiding even other participants in the economic ecosystem, in the competition ecosystem in Africa, so that we are able to fully appreciate how to define this kind of concept. So basically, that is what we have been doing. With regard to prepare, we are also waiting for them. Once they are in place, we will actually engage them so that we have the memorandum of understanding before they implement the law. So that immediately they implement, we start implementing. Already we have mechanisms in place to address those concurrent jurisdictions.
Okay. I think that is music to our ears, that there's a lot of thinking going on in the background, and hopefully we'll have a smooth implementation of the continental regime that doesn't cause too much disruption for business. Willard, let me come back to you. I think I want to give you the opportunity. If the After Competition Authority head was sitting here today, and you had a chance to give him some advice about the do's and don'ts that they must be aware of as they start this journey, what would you say to him or her?
I address that. I think it's very nice to hear sister here talking about convergence, actually, that they are already working to ensure that their law is in harmony with the EAC law. That is very good. And my good friend from CAK, I think, has also made mention of that. And I think the model between CAK and COMESA in how you should work together even where there is seemingly some conflict in the law, not between persons, in the law, is a good model, a good approach to implementing these things. As I said, we are not in these offices for ourselves. We are in those offices for you and your client's choice, to make sure that business is smooth. And CAK mentioned a very important thing. You need people who are pragmatic, who realize the problem and say, what is the solution to the problem? When we commenced the COMESA, the implementation of the COMESA competition regulation, the law in Kenya was very clear that you should also notify here. So when the Kenyans said it should be notified here, they didn't say anything wrong, by the way, because that's what their law said. But you needed people who are problem-solving oriented, who are pragmatic, to say, okay, here is a challenge that is before us. How do we resolve that? And I think sometimes it's easy to criticize. There was lots of criticism between 2013 and 2015. We are human beings. We are born to criticize, so I understand that. But it's easy to criticize sometimes. We are dealing with sovereign nations here who need to change their laws if you want to see what you desire to see. So between 2013 and 2015, CAK and COMESA finally coming up with that arrangement that transactions that are at COMESA level should not come to CAK and vice versa. Would not have been very easy as people would think, because it required the involvement of so many people. I'm looking at Francis Kariuki here. It required the involvement of so many people. I know there was so much communication with the Attorney General in Kenya, so much interaction with Parliament in Kenya. All those are processes that take long. But what was gratifying and what we would want to see going forward is that there should be practical men and women who realize and recognize the problem and say, what are we going to do about it? Rather than saying, this is a challenge that we have, we can't do anything about it. This is what my law says, I can't do anything about it. No, that's what your law says, there's something wrong with that law. Tell us that I've seen this is wrong. This is what my law says currently, but I'm doing A, B, C, D to try to address this problem. Okay, and that takes me into the lessons for the AFCFTA. One of the lessons I've already just said it. You need to be very pragmatic. And for them, I think the opportunity is actually there because that protocol is not in force yet. We also need to come up with regulations. So there's still some processes to take place before the protocol is finally enforced. There is a lot of lessons that they can take into account to make sure that we do not see the problems that we are discussing here. So the first thing I would advise them is that the very same thing I've said, that whoever will be there in that office, maybe it will be me, whoever will be there in that office should know that they are not in that office for them and to safeguard their interests. They are in that office to safeguard the business at continental level. Number one, once you have that realization, it's very important because then you will have that appetite to do the right thing. And the appetite would be, let me see what is happening in Kenya, let me see what is happening in Tanzania, let me see what is happening in ECOWAS, let me see what is happening in CEMAC, and make sure that we create a system that is seamless without conflict. It is now. And in those regulations, we can do that. The second thing is that they should be looking at, as I'm happy with one of the provisions in that protocol. I think it's Article 11, if I'm not mistaken. Yeah, that is talking about gatekeepers and these things. I think so.
Article 11,
like It's Article 11, right?
Yeah.
Yes. That is a very important article in that protocol. Why am I saying this? If you look at most of our laws, regional or even national, they are not yet very advanced as when it comes to those issues. That Article 11, if it can become a model for all laws, national and regional, to adopt, we are already moving towards harmonization, for example. So that is very progressive. And it is things like that they should look at. So the next thing that they should look at is to enhance capacity and call for the review of laws at national, even regional level. Okay, so that these laws fit into that structure without any conflict. Okay, so that is very, very important. And then the third thing for me, where they should also focus their attention is on capacity building and advocacy. Okay, I want to put Francis on the spotlight here. When COMESA commenced its operations in 2013, one of the things it decried so much about was that this thing was not known. All of a sudden, it just dawned on us, boom, there's COMESA. Okay, but I think we've tried to correct that scene because now we've talked so much about COMESA. The AFCFTA should also make sure that they do not fall in that trap or that mistake. Even before the implementation of the protocol begins, I think it should be very well talked about. There should be lots of advocacy so that everyone understands, not just waking up today and say, Joyce, now you have to notify at the continental level. And then the last thing, which I think, Lydian, don't look at me like that. Which I think we tried to do because initially it was not there. Okay, as I said, we want to save business. Initially, even at the AFCFTA, the way the law was, you would have been notifying at AFCFTA, you notify at COMESA, you notify at EAC, and probably some countries that are not part of this system. So we made it very clear, and I hope when the regulations are out, because they'll be implementing regulation, we made it very clear and gave lessons to the AFCFTA that let's have thresholds that will be very clear, that certain transactions of a certain threshold should not go there, and other transactions of a certain high threshold should not go to regional or even national, should go to the continental, so that we avoid this issue of double notification and everything like that. So that would be my guidance to AFCFTA. I would tell them, number one, you are not in that office for you, you're in the office for business. Since you're in the office for business, do the right thing for business. And then remember that countries are sovereign. Don't impose things with them, on them. Discuss with them, engage them, come up with solutions. They will have a buy-in. And then finally, please ensure that you also advocate for legal reform and capacity building at national level. Then we are all on the same page.
Okay. Thank you so much, Dr. I want to open up questions to the floor. Do we have any questions online? No, none at the moment. Okay. So maybe as I wait, I want to ask Juan, as an experienced competition lawyer in Europe, and the EU has been, the Commission has been active for a very long time. Can you share some learnings, some successes, some do's and don'ts that perhaps the colleagues in the panel, the experiences of things they should avoid and things perhaps that they should do?
I'm actually very heartened to hear the discussion we've just had, because I think you know the do's and don'ts from what you've explained. In terms of successes, what could be seen to be successes in the European system? I think first off, the merger control system that we now have and the delineation of jurisdiction between the EU Commission and the member states. When a case goes to Brussels, when a case stays at the national level, when parties themselves can choose to navigate a case to Brussels that otherwise wouldn't go there, or vice versa, because all thresholds that delineate jurisdiction need to have corrective mechanisms. No thresholds are perfect. There are always exceptions where the strict application of the thresholds leads to a perverse outcome. So that system seems to work well. I think if you ask most European practitioners, they would say that the introduction of essentially federalized merger control in Brussels in 1990 has been a success. But it's sort of a success in spite of itself, because it wasn't always seen as so successful. There was like a little bit like when a person's growing up, before you have the child, there's a lot of anticipation and hope, and how's it going to be? The child arrives and it's a little darling and can do no wrong. And that was the sort of the early years of merger control. And then it becomes a teenager and you wonder what it is you have created and where it's going to go. That was sort of the early 2000s, when the Commission suffered 3 very embarrassing defeats in the General Court, 3 cases, Airtor's First Choice, GE Honeywell, and Tetra Laval-Sidel. And that led to a complete rethink in Brussels and a complete reorganization of how merger control was administered, and the introduction of a more economic approach. Then in 2004, there was a further change to the regulation to be the current, essentially the current set of rules that we live with. So this has come over time, and there have been teething problems that have had to be addressed. The second success, which frankly shows that business's concern expressed at the time was unfounded, was the move to a self-assessment system for restrictive agreements. We used to have in the EU since 1962 a system of notification for restrictive agreements, which you may think is bonkers, is nonsense, because if people are going to do a cartel, they're not going to file it with the Commission. In fact, they're going to do the opposite. They're going to do everything they can to hide it and to dissimulate it. But the system was configured in a way that was based on notification. So if you had an agreement, clearly cartels were not notified, right? So this system caught relatively innocuous agreements, business agreements that had exclusivity provisions, non-compete in joint ventures, what have you. And Brussels became a clearinghouse for the notification of innocuous agreements. It was a ludicrous system, and the Commission realized that it was ludicrous and that we had to move to a system of self-assessment. But there was a massive outcry from business who liked the idea of notification, who liked the idea that you go to the Commission, you notify, and it becomes their issue. And then you get a decision at some point. In fact, you didn't get a decision, you got a thing called a comfort letter because the Commission didn't have the resources to issue full decisions. And we moved away from that system in 2004, and that has been a great success. But the business community, I can tell you, was very, very, very wary at the time. On the failures side, I could spend a long time talking about the failures, but I think probably for me the biggest obvious failure is the valueless appeal process in relation to mergers, which may sort of contradict what I've just said about the merger control system working. But honestly, if you are a party to a merger that gets cleared, that's great. But if you're a third party that doesn't like a merger that's being cleared and wants to challenge it in the general court, that is a valueless thing to do. Why? Because it takes forever. You don't get a judgment at first instance for at least 2 years, 2 to 3 years. Then on appeal, maybe another 2 years. And if you succeed in the general court, what happens? The case goes back to the Commission for reconsideration, and the Commission can rectify the error that led to the appeal being successful. So that for me would be a significant defect in the system. The other one, I'm not quite sure whether it's a success or a failure. It's certainly a success for the lawyers and the economists involved, but this is the explosion in follow-on damages litigation in cartel cases. This has become a massive cottage industry and a huge, huge cost to business. Great for the economists, great for the lawyers who get involved in this, but I think a consequence that nobody ever foresaw, and certainly if you talk to many national judges, they would not necessarily see this as a great thing because they're busy enough as it is, and to have to deal with this explosion of complex, fact-driven, economic analysis intensive cases is not a consequence I think they would have wished.
Okay, thank you. Willard has something to say to what you said, Juan.
He raises at the end there is very, very critical. So in the draft law that we have, there's that debate. There's lenience obviously that has been introduced. I was saying if a cartel is successfully prosecuted at COMESA level, should those who were affected by the cartel bring in private action against those parties? So it's a huge debate that we are having now. Others are saying yes, because damage has been done to those people and it's their right. Others were even saying constitutional right. It's a constitutional right to go against those guys in private damages. Others were saying that would be very dangerous. Because if you are talking about leniency and whistleblowing and everything, and those companies are aware that once the issue is settled at COMESA, there is risk that there will be this avalanche of litigation against us. That will also discourage them. So it is still something that is being discussed. It's a draft, and that takes me to this. So it's very important to hear that so that we continue having that discourse. That takes me to the next comment I wanted to make before I put down my mic, that look, lawyers and businesses yourselves, you should be seriously involved in the development of these laws. You should be seriously involved. Don't be comfortable sitting there when the law is there and is implementable, and we all know no matter how much you complain, the law will not change tomorrow. So don't wait for the law to come out, then you start. I see Bowman's right. You do a good job most of the times. You are writing those briefs and what.
Most of the
talking
time.
about certain things that are a problem, that is appreciated. But also learn to talk even before that law comes into effect, so that you'll be able to say, these are the problems we are seeing now. I, as Joyce, I spoke about this, I wrote about this. I've observed, Francis, in most of these meetings where we sit developing these laws, I don't see businesses there. I don't see lawyers there. I see people sometimes coming from government institutions who are neither lawyers nor even business people, drafting laws that we don't understand business, by the way. It's the business people that understand business. Worse still, people coming from government authorities who are not even lawyers, drafting laws that will be how. It's very difficult then to foresee how effective that law will be. So I call upon lawyers and businesses also to, number one, be involved. Number two, demand transparency, because again, you can't be involved if those who are doing that are not opening the door for you to be involved. Okay, so demand transparency. Those briefs that you talk about, right, so that you shame us. COMESA is doing this. We've not seen them involving any of the lawyers, and what we are not sure the law that will come from them, if it will be an effective law. Then we'll be shamed and say, oh, this law then will not be very well taken or appreciated. So please get involved as lawyers as well. Don't wait for bad laws, then you start criticizing.
But thank you for that challenge. I think those in the room ought to take up the challenge, and I assure you that Bowmans is working very hard to make our submissions on the draft regulation that the Commission has issued. I'm told we have a question online. Yeah.
Yes, so we have 3 questions online. The first one is for Lillian. And the question is, Kenya is a member state of COMESA and EACA. Would both regional organizations have some sort of cooperation framework? And what would happen in the event of potentially conflicting interests of the CCC as well and EACA? So both Lillian and Willard can take that one. Yeah. Yes.
Thank you for that question. I just want to go back to what Wiran said earlier, that we've been working together, because we realize really we have 5 out of 7 actually members of COMESA. And like you said about amending the law, because our law talks about, or the regulations that we have, that when we have a manager that is touching maybe 2 partner states, and we realize, let's say Kenya and Uganda, and we realize the impact is more in Kenya, we can defer the matter. But when it comes to regional matters, it doesn't really say we can defer a matter to COMESA. However, we are also considering that amendment. It was when we were really doing the amendments that we currently have, that thing had not really come, it had not sunk until now we've gone deep down into the law. So just like Wiran said, it will be in our next set of amendments. Yeah, because we didn't need to have a situation whereby we are able to refer matters. For example, if COMESA didn't realize the impact is more in Uganda and Kenya, we say East Africa is the most integrated regional bloc. We are like this, we are really so tied. And so maybe we can have that provision. This is a matter that we've actually even brought, has been brought before our legal institutions and even our council. So they are aware. We are trying to see how we can deal with it. And we've been having actually legions of AFCFTA meeting together. And this is one of the matters that at one time I brought up. So what we are doing, just to respond to the question, is that ourselves and COMESA have really been working so hard because we do not want to burden the business community. Our job is to ensure that we really encourage investments to come to our region. So we've been negotiating an MOU, and we are hoping to conclude, and we've discussed some of the issues on how we are going to resolve this, even as we wait for the amendments, because I know amendments can take long. But meanwhile, we'll see how we are going to deal with this, and I'm happy Willard is here with me. We are just about to conclude that MOU. Yeah. And then with the partner states, it's actually a requirement that we have to work together, and we're supposed to develop cooperation frameworks. And that's why we are doing it, so that we're able to work seamlessly without any challenge. But in matters where it touches Tanzania and South Sudan, at least I think there we've no issues. The issues come when we are dealing with the other 5 countries. Yes.
Okay. Thank you, Lillian. I think we'll just take one more question because we are running out of time. And it's a question for Dr. Willard Mwemba. Is the CCC considering a review of its filing fees in light of its objective to facilitate business and not to hinder it?
I thought we moved past that era. There was a time when I was very famous during the 500,000 US dollars notification fee. I thought when we came down to 200, the problem had been resolved. That one is not something we are thinking of. And look, not just because of COMESA itself, but also the member states, okay? These are interesting debates. I recall very well when we were at 500,000 and there was all this outcry from the business community, and we proposed for that amendment. And when we're discussing with those, with the member states on the reduction of those fees, I remember 3 member states, I will not mention their names, who stood up and said, what is the problem with CCC? Why are you thinking about reducing those fees? And if you say they are high for who? In fact, they should be increased. So those become very interesting subjects that it is beyond just the CCC when you start touching on those matters. However, from my side, I don't think it's something in the draft that we thought about. But as I said, lawyers should be, and businesses should be greatly involved. So we have a draft now. It's a repeal, it's an overhaul of the entire law. So if you think those issues should be among that, those that should be amended, you bring them, obviously with proper justifications, not just an emotion that 200,000 is a lot. So you have an opportunity of bringing it up. Thank you.
Okay, thank you so much. I think we are out of time, but thank you so much to the panelists for that engaging, very informative discussion, and the end. Thank you. So I think we'll move on. We had anticipated a break, but I think we'll hold that off for a bit. I'm going to invite my colleague, Wangombe Kariuki, to introduce our chief guest. Thank you.
Good morning, everyone. Thank you, Joyce, and thank you, the panelists, for that kind of stimulating panel. Before I introduce the chief guest, is that there are 4 people I would like to recognize in this room who have not only shaped my career, but also my personal life. And one is Esther Koimet, who I worked with in Treasury. All my successes relate to Esther, all my failures relate to me. And Esther, thank you very much. The other one is retired Judge Davis. Davis, although he has no kind word for economists, this is a gentleman who has taught me to say what I think. And when we meet in concurrences, I've learned a lot from Judge Davis. Thank you, Judge Davis. The other person is Lilian Mukoronia, the registrar of the East African Community Court. This is a person we were employed the same year, we were sharing the same office, and she helped me choose my partner. So Lilian shaped my life, my personal life. The other one is Willard. Willard, there is a boy, I was in the interviewing panel. Some people are opposing his employment. I stood with him, I stood by him, and he's doing good work at COMESA. All those are people I'm really, really proud of. And I've become a politician. I was given 1 minute, but I had to steal another 1 minute. But now it's my honor to introduce Dr. Mukwana, Dr. Mukwana, the Principal Secretary in the State Department for Industry. Industrial policy and competition policy, there has never been convergence of thoughts, how they should relate. And I think that's why we call Dr. Mukwana, because also industrial policy and competition policy discussion has changed since the COVID-19 a pandemic. And we have seen with the coming in on board of Mukwana, quite different policies being developed to support the industrial policy, but also respecting the competition policy. And Daktari, as you come here, is that I have to warn you that most of these are lawyers who read in between the lines and also read the spirit of your speech. But I know you're up to that game. And let me take this opportunity to welcome you, Daktari.
Thank you, Angombe. The team from Bowmans, distinguished participants, lawyers, my sister Esther, and others in the room, good morning. Yeah, as he has said, today I have a very difficult task of a veterinarian trying to prosecute something before the lawyers. So we shall try and see how this goes. I am here on behalf of my CS, Esther Miano, Rebecca Miano, who is away in Doha, and she has given me some notes to pass to you regarding the discussion of competition. But before I do that, let me say that we really want to appreciate. I'm told this is the first time that a conference of this type is being held in Kenya, and we really appreciate Bowman and all of you for coming to Kenya, because as you can see, if you are in Kenya 2, 3, 4 years ago, you definitely have noticed that it's becoming very different, whether you are in Nairobi or you go to the rural areas. As Kenyans, we complain quite a bit. So you have to get used to us. But those of you who are here 5 years ago, I'm sure when you come to Nairobi, you see quite a difference. The other issue that I wanted to do, because I represent industry before I read this speech, is really to put in perspective what we are trying to discuss here. Because I think sometimes we can get bogged down with these protocols and these laws, and then we forget exactly what are we trying to achieve. Because I represent industry, I have taken a lot of interest to look at Africa and industry. Because a lot of the investments and a lot of the competitions that you'll be talking about will be having something to do with value addition and industry. The last time I looked at these statistics, let's step back a little bit, that the first industrial revolution in the world taking place 17th, 16th century, 18th century in Europe, driven by the steam engine and labor and raw materials, and the rest of the world. So from the first industrial revolution, we have moved to the second industrial revolution, the third industrial revolution. This time we are all talking about the fourth industrial revolution that is being driven by information technology. But the question to ask is, when people are talking about this fourth industrial revolution, where is Africa? Are we in the first? Are we in the second? Are we part of the fourth? Where are we? And sometimes I'm told, if you are not at the table, you are likely to be, you could easily become part of the menu. So as people are talking about the fourth industrial revolution, here in Africa, we are not sure whether we are even at the first one. And that really creates, for me, the background that we should be addressing this issue with. When I also looked at the share of manufactured products in the world, Africans, 1.3 billion people, 55 countries, we are 17% of the world population. But our share of manufactured products in the market globally is less than 3%. So here is 17% with a market share of manufactured products of 2.8%. Let's look at Europe, because I saw my brother from the EU here. The EU population, 27 countries, is 9% of the globe. But their share of manufactured products is 24%. So for me, therein lies the issue. And so as we talk about competition, as we talk about creating laws and protocols that will guide Africa, I think that we are already in a deep hole. And the question is, do we continue digging the hole, or are we getting a rope to get out? So whatever we do, whether we are talking about COMESA or EAC or AFTA, what are we talking about? Because I think for me, that, and the other statistics that I want to share, which you already know, is that if you look at intra-Europe trade at 70%, meaning that the goods and services traded within the EU are 70% made within the EU. If you look at Asia, they're talking in the range of 40 to 45%. When you come to Africa, the last time I looked, it was 15%. So Africans doing business with themselves is 15%. So what should we be addressing? How to compete or how to collaborate? I don't know how to put it, but you get it from yourself. Is there sufficient business among ourselves before we even talk about whether we are competing properly? Because I know this is a competition meeting, but if there isn't enough volume of business, how do we then make sure that even those laws that we are putting together really facilitate Africans trading with each other? And for me, that is very critical, because in theory, when I look at the structure of Africa, we talk about a population of 1.3 billion. Therefore, this is a good market, but it is a different dynamic. China has almost a similar population. India has a similar population. If I was to set up a factory today to target 1.3 billion people or thereabout, if I go to China, I have one standard, I have one regulation, I have one competition law. If I go to India, almost a similar number of people, consumers, in fact, a better middle class, meaning that there's better consumption. We are talking about Africa, 1.2 billion, very much lower middle class, very separated. The 1.2 billion that we are talking about Africa, with 55 countries, 55 different laws, sometimes 55 different standards. Then we add in the confusion of, I'm sorry to use this word, learned lawyers. Then you add in the confusion. Now we are already 55, we have different laws, we have different standards. Then you add in the confusion, you have the EAC, then you have COMESA, then you have SADC, then you have SADC talking to COMESA, then you have tripartite. I don't know. Which business are you facilitating? You are part of the confusion. Let's take a practical example. So we are talking about Africa trading with each other. If I have a consignment of tea, and I want to sell this tea to India, I move this tea from Kericho to Mombasa, and within 5,000 kilometers, I will hit India. If I'm exporting this tea to Cameroon, I hit Mombasa, then I have two choices. I have to go down to Mozambique. I have to go to Cape Town. and go around. By the time I hit Douala, it's 10,000 kilometers. If I go the other side, the Red Sea, by the time I hit Senegal and come to Douala, it's almost 13,000 kilometers. So the Africa we are talking about, if I'm flying from Nairobi to Douala, it's only 4 hours. But that's not how we move our goods. So Africa looks like we are one. So we talk about Africa. And that is why sometimes, if we are only doing business with each other 15%, it means 85% we are doing business with other people who are more convenient, who are nearer. So logistically, some parts of Europe would be nearer than parts of Africa, moving from Zambia, sailing to Senegal. And so as we put these laws and protocols, and as we talk about them, somebody said here, what we are looking for are legal frameworks and protocols and agreements that facilitate trade, that are progressive to bring in emerging technologies, digitization and other things. But we must also put them in the reality of Africa, that we are a big potential, theoretically, a big population, a big continent, endowed with a lot of resources. But if I'm doing more business with China than with my neighbor, one of the things that fascinates me about the AfTA, and last time I was talking about this, that we as Africans found it relevant to sign. I know when this government came into power, the people who had ratified the AfTA were about 37, and we worked very hard. Now we are about 54. We found it good to sign a protocol to do business with each other. But on the same table of the African Union, there has been another legislation sitting there, a protocol called Free Movement of People. Last time I checked, it had not been signed. So the question I was asking is, how are you going to do business if you can't move from one country to another? Are we going to do this by osmosis? By active diffusion? So if you can't move, how are you going to do business? And so my view is that Africa has a lot of potential, and we all know that. If you reverse this clock 150 years ago, my grandmother would have been dancing with her boyfriend somewhere on the plains of Zambia. The Bandus of East Africa, the Bandus of Cameroon, the Nilotes of Sudan. So we have these boundaries that are created for us. Interestingly, the people who created for us in Europe, today you drive through from Germany to wherever you want to go, Netherlands. But for us here, we are stuck. So we have all these complications of us. We have very tight borders. We have non-tariff barriers. We introduce rules. Then we introduce through the back door other things. And we are only producing 3%. And we are only doing 15% of our business with each other. But we are more busy closing the doors than opening the doors. I heard somebody talking about sovereignty. What is sovereign about an African country doing business with China and closing business with its neighbor? And the way I've said it is, there is no way Kenya can succeed if Uganda is not successful, because we are tied together. We are brothers. We are one people. And so part of what we should be thinking about really is, how do we open up more business? Even if we want to compete properly, we can only compete properly when there's sufficient business. If you only have a drop in the ocean, then, okay, we will. So sometimes I think I've attended quite a number of these meetings at the EAC in Arusha. where we can argue about a comma for two days. We are talking about a tariff split, and we can argue for, I told somebody, and Esther here was in this business, sometimes in Africa, we spend so much time negotiating trade between two countries. We spend millions, and we spend 3 years, 4 years negotiating trade. Then once we sign, there's no business. Sorry. So you spend 5 years negotiating a trade agreement between Zambia and Ghana, and we have many delegations flying left and right, and they sign the agreement, and when you go back 3 years after they sign, no business has taken place. So we spend a lot of energy. It's like a factory that closed down its processing, its production. But the marketing department is very active, selling products. So we have thousands of trade agreements between us. But the volume of what is it that we are selling after we have agreed? So the next time we finish this trade agreement, we move to the next trade agreement, and nobody's asking, so after we close this one, how much did we sell? So we have so much documentation. We have so many laws at the country level. We have so many laws at the regional level. We have more laws than the goods we are trying to sell. We are spending more time developing laws than developing business. And so my take is, as we talk about competition, really we know that the bottom line is to grow business between African nations. We have laws that we make 5 years down the line, nobody has even looked at them. So I know that it may not be directly your duty to create more business between African countries, but this discussion and these protocols that we are discussing, competition protocol for the AFTA, should be able to facilitate trade between us. It should be able to subsume some of the regional protocols that we already have so that we don't have conflicting. One time before I came to this life, I was working in the qualification sector. And we were trying to create an African continental qualification framework for the AU. And before I came into that space, I didn't understand how confused the whole state is. Let me use a simple example. In Kenya here, our education structure is before we came to this one, we do 8 years of primary, 4 years of secondary, and then 4 years of university. You go to Burundi, and they're doing 9 years of primary. Then you will do another 4 years or 3 years of high school. Then you do 2 years of A-level. Then you do 3 years of university. So the question we're asking is, if I'm a parent who is in Burundi, and my kid is in grade 9 in Burundi, and I relocate to Kenya, where does this person start? If you are in Form 5 in Uganda, you have done your O-level, you have done, and you come to Kenya, which class do I join? So we were trying to create a framework for interconnectivity and interoperability of our qualifications across the continent. Because what we found is that when Africans moved from one country to another, they faced a lot of challenges because nobody can determine even what your qualification means. We spent a lot of energy. Eventually, we created a framework, but we found that part of that was to say, can we subsume? Because the SADC region already had the South African qualification framework, they had the SADC qualification framework, the ESC had the ESC qualification framework, and the challenge was, how do you create a continental framework that does not conflict with the regional qualification frameworks. And the regional qualification framework must be in harmony with the country, the Kenya National Qualification Framework. So no other continent in the world faces this kind of challenge. There's no other trading bloc in the world that has so many subsectors, that you have a country situation, you have a regional situation, you have an inter-regional situation, then you have a continental situation, and you want all these things to work together for the benefit of the business person. It is very, very confusing. If I'm a businessman in Africa, I'm not sure. And that is why sometimes we talk to ourselves, because we also found the same situation that you have here, that our education systems were different. So some countries were following the British education system. Others were following the French system, the Portuguese system, the Arab system. So how do you put these four to create an African continental qualification framework that works for everyone, that is understandable, that's clear, that is simple? And I think the challenge we have here is the same. How do you create laws and protocols at the continental level that respect these regional groupings, that are not in conflict, that are facilitative, that also then respect the sovereignty of these 55 countries, but at the end of the day, that facilitate business, that are even understandable? Because if I'm a businessman trying to do some business in COMESA and SADC, I don't want Latin. I want something that's clear for me. I don't want to seek legal services every time I have to do a small transaction. So my view is, let me really thank you for the courage that you have, the fact that you're thinking about a continental protocol for managing competition within the FTA system. The complications and the challenges are clear for us. The law should serve us, not be against us. It should facilitate business. It should be simple. It should be clear. It should facilitate intra-Africa trade, intra-regional trade, so that we can create prosperity for our continent. I thank you for your listening.
Thank you so much for those very wise words. I think we will take a break of about 15 minutes so that we can try and make up a bit of time. So let's congregate here. What time shall we come back? 11:15. Thank you so much, everyone. Good morning once again. Thank you. We're now prepped up for panel number 2, which is going to be moderated by my partner, Heather Irvin, who I will introduce, and then I will hand over to you to introduce your panel and the topic. So Heather is a partner in the corporate department of our Joburg office and a member of our competition practice. She specializes in complex mergers, competition law complaints proceedings, and pricing. She has particular expertise in the mobile, telecoms, financial services, broadcasting, and manufacturing sectors. Heather launched 2 of the first applications in cartel cases in the Constitutional Court of South Africa, and she has managed several dawn raids for clients in both South Africa and Zambia. Heather has a BA and honors degree and an LLB from the University of Cape Town. She also has a competition law certificate from the University of Wits and has been an external examiner in undergrad and master's competition law courses at the university for the past 5 years. Over to you, Heather.
Thanks so much, Joyce. And I'd like to abuse my position as the moderator on this panel just to pay very short tribute to Robert Lee, the former chairman of our firm and one of the founders of our competition practice. I think it would have made Rob immensely proud to be sitting here in Nairobi, and particularly proud of all the Bowman's partners who are working to grow our practice across this wonderful continent. So without, thank you. Without further ado, I'd like to introduce our panel. We've decided to dispense with long introductions so that we have more time to talk about digital regulation. But just so you know who's here, these are all good friends of our firm and people we work with often. First up, Wangeshi Gichuki. She's the head of legal and secretarial services for Safaricom. Then we have Angie Maseko from Genesis. She is a senior associate and recently moved to Nairobi, which sounds wonderful. Jacob Muller from RBB is an associate principal in Johannesburg. And not to be outnumbered by economists, we do have some lawyers on the panel too. Judd Lurie is a partner in our Johannesburg office. And then we've also got Mutuku Mategi. He's a senior associate in our competition practice here in Nairobi. Welcome everyone, and thank you so much for joining our panel this morning. This panel's on digital regulation, and of course this is a very topical subject. At a recent conference in Brussels, which called itself the Anti-Davos, and which was called by Politico the Woodstock of antitrust, the panelists called for new measures to address what they identified as a new global threat, namely big tech. Europe has embarked on a very ambitious and unprecedented experiment to regulate digital gatekeepers under the Digital Markets Act. And of course, the unintended consequences for consumers and debates about the impact of compliance on innovation, accessibility, and efficiency of digital services have already begun in Europe. Americans, on the other hand, are undertaking a much broader examination of how corporate power is amassed and wielded and what its consequences are, not only for consumers, but also for workers, the environment, and society at large. And this means it's a very timely opportunity for us to be here and think a little bit about how competition law enforcement is happening in Africa in the digital space. What sorts of new initiatives are we applying to be able to deal with the big tech power being wielded in African markets, and how effective are those efforts likely to be? And of course, to what extent can we expect to see convergence? So to kick us off on that score, it would be great to hear from Matugi if you'd like to talk to us a little bit about some examples in the Kenyan context where we've seen enforcement of competition law in digital markets.
Thank you, Heather, and welcome everybody to Nairobi. I hope it's not too hot for you, especially those coming from the Northern Hemisphere. But I think for Kenya, what has happened really over the past decade or so is we have seen it had started off very slowly. There wasn't much of a focus on competition compliance focus in the digital realm, but the first time that we actually saw it as practitioners, I would say was, at least in the merger space, was a few years ago, where typically, as some of you, as most of us will know, we have various thresholds for notification, and you'll find you'll have no filing required, and you have an exclusion where it's a very top level assessment, and you have a full filing. And we had the first notice of focus on the digital space was where there was an acquisition of a microfinance bank by a player in the digital finance space. and which typically from a factual assessment would have been considered to be an exclusion when inquiries were made with the, when a filing was made with the authority, the competition authority. They took the approach that no, because of the overlaps and the significant data data holdings of the target in that matter, it was considered to be a full filing. So the authority could have an opportunity to go through the entire consideration, what these overlaps would manifest as and what kind of implications that may have from a data protection perspective, and this was before even the Data Protection Act in Kenya came into play. So it was a very, well, it did catch a number of people by surprise, but well, it was understandable in the circumstances. I think what followed then after could be said happened mainly in the telco space, where interestingly, it brought to the fore the issue regarding concurrent jurisdiction that occurs, which is very typical in the digital space. You'll find it across fintech, where the central banks, Reserve Bank in the case of South Africa, have a role to play. Then you'll find it as well with data protection regulators, what they have to think about that, and also the communication regulators. And that's kind of what happened in Kenya, where the Communications Authority initiated a market study on its own volition and did a very thorough market evaluation. And of course, a lot of debate happened about where do these entities relate with each other, how do they share information, when suggestions are made, what do we consider, and how, if enforcement is to be done, what kind of assessments economically, from a public interest perspective, and more importantly, from a competition perspective, need to be put in play. And I think most recently, something which is about to come to a close, I think next week, I wish there was somebody from the Competition Authority inside here. They might be to confirm it. But exactly 1 year ago, the Competition Authority of Kenya initiated a market inquiry into what they call the online food delivery, food and groceries delivery in Kenya. Of course, anybody who has been monitoring what's been happening, that has very strong rhyming with what has happened in Europe recently and closer home in South Africa with the online intermediaries and platforms market study as well. And what happened here in this case, they were trying to, initially the Competition Authority was trying to focus on it from an angle of abyss of market, abyss of buyer power, almost mixed up my words, but abyss of buyer power. And it was a very interesting perspective. The reasons why practitioners might think of that, because in Kenya, you don't need to prove dominance before you can prove abyss of buyer power. And that's probably one of the angles that was being sought in that perspective. But what resulted initially, they decided to do a full-blown market inquiry, which I believe as we've been informed, the results of that study should be published probably next week, and we're looking forward to see what the authority says there. But they have given us an opportunity to see with the preliminary comments, which I'll touch on later on. But it just gave an opportunity to see as well that this focus is happening, not only some of these focuses are being informed not only from the local dynamics, but also what international perspectives are being considered, not only internationally further out, but right here in the African continent, what say is happening in Egypt, what is happening in South Africa, and trying to bring it closer home and see how that impacts us at a more local level. Yeah.
Great, thank you. We're going to come back and talk in some detail about market inquiries. But before we turn our attention there, Judd, anything interesting in happening in terms of enforcement of competition law in South Africa?
Thanks, Heather. So the South African Competition Commission's foray into digital markets really began in 2020 when the Commission published a paper on competition in digital markets. And essentially in looking at these markets, this was really an introduction from the Commission. The Commission acknowledged that in the context of South Africa, because of COVID, there'd been a rapid rise and a rapid adoption in the use of digital platforms, particularly, for example, in the online shopping space. The Commission thought that the advantages of digitalization meant that there were opportunities for social upliftment in South Africa, for employment creation, for poverty alleviation. But at the same time, the Competition Commission cautioned that what might be an unintended consequence of big tech is marginalization of vulnerable South Africans. So as a result of this, the Commission set out an outline of what it planned to be a proactive approach to looking at these types of markets and how it would address the concerns that it had identified on a preliminary basis. The Commission announced that what it would intend doing was introducing thresholds that were different to our ordinary thresholds for the notification of mergers. And those thresholds were particularly to address digital mergers or mergers in the digital space. Those thresholds were ultimately published in non-binding small merger guidelines. So those are mergers that fall below the thresholds. And what the Commission is focused on there is either the value of the company or, for example, the purchase price in determining whether or not a merger should be notifiable. And in that regard, the Commission expressed concern that there were a whole lot of these global mergers going on where, for example, startups were bought. And this was leading to an increase in concentration that basically went undetected. As Heather mentioned, we're going to turn to market inquiries in quite some detail. But insofar as market inquiries are concerned, the Commission announced that it would be conducting market inquiries. And indeed, that is what has happened. The Commission conducted an extensive and lengthy inquiry into online intermediation platforms. And what it has also started is a market inquiry into news platforms. And essentially, what the Commission is looking at there is the dependency of South Africans on, or South African businesses rather, on global media giants, essentially, and how they monetize their content in this regard. In addition, the Commission has keenly observed developments in other jurisdictions. So far in the merger context, the remedies that we've seen have really been related to access remedies. So, for example, a company's got access to key information. What is the possibility that they will post-merger foreclose others from accessing that information? And those have been types of remedies that have been imposed to date. There is a merger that was prohibited where the Commission looked at an ecosystem theory of harm. And essentially that was also linked to information whereby there was a concern that the firms that were merging had information in both the digital space as well as in the bricks and mortar space, and that there'd be a cross-pollination of that information, which would essentially create an entity that nobody could compete with. The Commission also, in that paper that I mentioned, lamented the fact that it had approved a whole lot of mergers in the digital space. I think the figure they gave was 87, where they hadn't imposed competition-related remedies. They'd missed the opportunity, whether rightly or wrongly. So I think key developments in South Africa in merger control is that where digital mergers are notified, we're going to see an increase in scrutiny. And that will be in terms of the Commission's public interest mandate, which it is pursuing vigorously at the moment, particularly as regards local ownership. And in addition, from a competition harm theory point of view. So I think that's really what we're going to expect. Insofar as cases that relate to behavioral concerns, so for example, abuse of dominance, what the Commission is looking into are cases whereby you've got platforms that the Commission regards as leading or dominant, and those platforms have allegedly denied third parties access to the platform. And that's what's being looked at under the lens of an abuse of dominance. In addition, what's been interesting to see is that those third parties that have been denied access have then sued interdictory relief before the Competition Tribunal, which has been granted. Thanks, Heather.
Thanks, Judge. So Angie, we see it being driven not only by the Commission, but also by private claimants who are using the competition route, and as Judge says, specifically applications for interim relief before the tribunal. Would you like to talk about that a bit?
Yeah, sure. So I can maybe perhaps give an example of a case recently that our team has been working on. So I know that there are other cases with respect to WhatsApp and GovChat, so perhaps Jad could speak to that specifically. But in terms of an interim relief matter that came about from a firm called dLocal, they are essentially a financial intermediary firm. They acts as a local agent for international firms that don't have local presence in terms of payments that are made, so e-commerce, so payments online. So what this would essentially mean is bypassing Visa's international system, meaning that merchants or consumers have cheaper rates and that they're not having to take up the international rates. So this is quite an interesting case and something that has come up recently. There has been a tribunal hearing and a finding that was recently filed. So it's something that I'm happy to speak about it in more detail after this in terms of the merits of the case, in case I say something I'm not supposed to. But yeah, I think it's just quite an interesting case in terms of payment systems and how we think about it in the digital sphere.
Thanks very much. And of course, Jacob, these cases tend to raise kind of real economic challenges. Would you like to talk a little bit about those?
Yeah, thanks, Heather. Yeah, so certainly we're seeing this greater scrutiny both of merger activity and individual firm conduct in digital markets. And we're seeing this increasing focus on issues around the welfare of small firms and fairness outcomes. In addition to those broader competition policy objectives and in ensuring the maximization of consumer welfare. But I think there are some particular complexities in trying to achieve those outcomes through competition policy in digital markets in particular, and also in developing countries. So I'll touch on these in a bit more detail when we talk about market inquiries next. But at a high level, I think there are three particular complexities. The first is that these concerns often center around concerns to do with tipping of markets, so the tendency of these markets to tip in favor of one or a small number of firms. Those firms then essentially acting as gatekeepers for businesses to access consumers and being able to potentially abuse that position. But I think what's important to understand is that these markets can still be highly contestable, even if they are highly concentrated. And indeed, the scale of these platforms is what generates benefits for the business users that use them, as well as for the consumers. So the reason that an Amazon is a useful platform for businesses to sell products through is that they have access to a significant proportion of the consumer market. Equally, consumers find it useful to use that platform because they can access a large number of businesses selling products. So when these markets are contestable, pursuing an objective of deconcentration can risk losing those benefits for the small businesses and consumers. Related to this, I think, is the idea that kind of the difficulty predicting the future in digital markets and in developing countries is often put forward as a reason to pursue a more interventionist approach. But we need to be careful in that regard, because you also risk false positives. You risk preventing conduct which would ultimately benefit businesses, benefit consumers, and benefit competition, precisely because it is difficult to predict what the future will look like in these markets. And then finally, I think an important thing to consider in these markets is that conduct which might on its face look as though it harms the ability of small businesses to compete, to access consumers, and particularly to compete against their larger rivals, are often short-term effects. And you need to think about the longer-term effects. Often this conduct is driven by a desire to for a platform to be able to attract consumers, to be able to compete more effectively with their own rivals. And in the long run, that gives greater benefit, greater participation opportunities to the businesses that use them. And so balancing those short-term effects against the longer-term effects is quite important when thinking about digital markets. So I think for regulators, what this means is that it's very important for them to really have a full understanding of the business models of these digital platforms, of the nature of competition, and also to set clear benchmarks when thinking about how you assess harm to participation of small firms. And for businesses, I think it's very important to be able to communicate a clear narrative around that competitive process, their own business models, and how their conduct is often driven by a pro-competitive motivation, even if on its face it might look like it has some detrimental effects.
Thanks very much. You mentioned regulators, and of course Muthugi also touched on the fact that in Kenya it's not only the competition authorities that enjoy jurisdiction. Wangeshi, do you want to talk to us a little bit about whether that concurrent jurisdiction has enhanced enforcement or raised some challenges?
Thank you, Heather. Before we started, I was telling Muthugi here, I'm not a competition expert, but I do engage in competition. Now, in the telecommunications space, our primary regulator is the Communications Authority of Kenya. And they have a mandate within their space of regulation to also look at matters competition, and this is found within the Fair Competition and Equality of Treatment regulations. Now, within those regulations, you will notice that from the outset, that the authority realizes and welcomes that there is need for other agencies to come and have concurrent jurisdiction and also to collaborate with them on matters competition within our space in the telecommunications industry. Now, like I said, the CA, we like to call it the CA in the telecommunications space, but we also know the Competition Authority is also the CA, so you can even see the collaboration from the outset, even in the naming. Now, when we talk about the Competition Authority's mandate when it comes to the telecommunications sector, it is one which is broader. It is market-wide. They are a superintendent of all matters competition. However, being the technical regulator of our space, the Communications Authority also has its say in terms of how we are conducting our business, how we are showing up in the market, etc. Now, this particular overlap or coincidence of mandates was also noticed by the National Assembly Committee on ICT. This is around 2019, where they realized that perhaps there could be some disharmony or there will be issues in terms of regulating effectively the telecommunications space. And this is because one of the regulators would be saying, I know these people, there's more than just a competition, so perhaps I should be the one taking the front line. But then you find another regulator that is more in-depth in the knowledge and experience of market-wide competition also coming and saying, you know, you are still in the same marketplace, so I should also have a say. So what then happened? What was the solution? Thankfully, both regulators were open to collaboration, and there was an MOU that was entered in between the Competition Authority of Kenya and the Communications Authority of Kenya. And this is, in my view, a very enriching experience because one will bring sector-specific experience, being the Communications Authority, and the other would bring the market-wide experience, being the Competition Authority. Now, we have seen this MOU at play, because as the industry, the telecommunications industry has grown, has matured, and we move at a very fast pace, we are starting to see a more pronounced presence by the Competition Authority in some of the things that we're engaging in. About two years back, not even two, about 2019 actually, 2019, 2020, there was a proposed merger between two of the players within our market, and we could see the real collaboration between the two, the Competition Authority and the Communications Authority, and we would find that the pronouncements they would make are truly a testament to their line of expertise. One would notice perhaps what are the resources that you have from a telecommunications perspective that needs to be thought through before we give a pronouncement on this particular transaction that you're proposing, while the other will come and say what would be the broader effect of the proposed transaction. So it is one that is good for us, and it is one that we can see is working, and we are quite happy when we see both our regulators coming together. Now, we find that one of the things that is happening is the cross transfer of information from one regulator to another, and therefore we are both enriching our spaces. So yes, I believe that the harmonious operation of both regulators has come to enhance competition in our industry.
Very interesting, thank you. So a couple of our panel have mentioned market inquiries, and of course we've seen a big shift into the market inquiry space in South Africa and Kenya, and I've no doubt this is something we're going to see more in COMESA as well. Angie, would you like to talk a little bit about the rationale for market inquiries and perhaps just touch on how they are a different exercise in some respects to abuse of dominance complaints of the kind you were talking about previously?
Thanks, Heather. So market inquiries are quite a powerful tool that we've been used more and more, particularly in the South African context, and I think we'll delve into that going forward in this discussion. And I think why that is because it essentially comprehensively assesses a market as a whole in terms of the general state of competition in that market or particular sector. And I think this is especially useful when you think about sort of the breadth of issues that could be examined relative to your more narrowly focused investigations when it comes to a firm's particular conduct or behavior. So when we think about why market inquiries are then conducted, it's really when the whole or a market as a whole isn't functioning optimally or isn't working well. And some of the reasons why we think about or how these things are indicated is when, for example, there could be barriers to entry, sort of limited consumer choice, or limited participation in the market by certain parties, or ineffective participation in the market. So these are sort of some of the economic justifications that we think about. And I think in digital markets in particular, there are certain areas of concern that we would think about as economists, such as sort of a gatekeeper, and I think that's something we'll discuss a bit more later. But I also wanted to highlight, beyond these sort of economic justifications, there are also some efficiencies that come from market inquiries, and as to why they are probably used as a pivotal tool. And I think one of them is the time considerations, for example, relative to specific investigations that can be quite burdensome and take a long period of time in terms of what needs to be achieved. And I think another example is the reach of remedies. And we've actually seen this happen, and outside of the digital markets, but in South Africa, when we think about the grocery retail market inquiry, coming out of that were consent orders where a few parties that were large retailers put forward or agreed to consent orders in terms of ending exclusivity or exclusive leases in certain malls. So this is where we see that reach of remedies in terms of how market inquiries are used. So this is some of the rationale that we think about. But I think market inquiries also have this extensive range of issues that could come about from it that go beyond the realm of what we think about typical provisions in the Act. And these can be quite nuanced or untested concerns that may arise from market inquiries, but they can also be issues pertaining to sort of fairness or other considerations beyond competition. And I think that's something we'll also discuss in a bit more detail as we move forward. And then just on the second element of what you raised, Heather, is just to speak about why they differ a little bit and in what regard we see that coming to the fore. So I think market inquiries tend to adopt a more forward-looking approach to identify potential competition issues and concerns. So they do not necessarily rely on ex-post assessments that you would typically see with investigations. But this is also somewhat different to what we've seen in the EU with, for example, the Digital Markets Act, where in the Digital Markets Act, it's really about how digital markets have already tipped. And there it's about thinking about how do we then think about creating fairness beyond a little, it might enhance competition, but there it's really thinking about how do we create fair outcomes once these things have tipped already. And I think another aspect to think about in terms of market inquiries is it's not an ex-post assessment, but it's also not strictly an ex-ante assessment. But what it does do is it offers sort of the advantage and the benefit of being able to address certain structural issues that might be features in a particular market that could be harming competition. And then lastly, just to note on this point is also that regulators across jurisdictions already have market studies or market investigations and inquiries within their toolkit. So this is certainly seen as one way to holistically view and assess a market. And in thinking about the digital market in particular, what's important is that it shouldn't be seen as an easy option. There's a lot of complexities when it comes to particularly digital markets, a lot of dynamism, and it evolves quite quickly. So this means that when remedies are put forward, there could be unintended consequences or negative consequences that arise from that. So this is something that needs to be carefully balanced in terms of how market inquiries are thought about.
Thanks, Angie. Matuki, you can talk to us a little bit about the experience in Kenya, because you've also been in the market inquiry space recently.
Yes. Actually, I think in the past 2 or 3 years, I think to my count, there might be around 4 or 5 market inquiries which have been launched. Some of them have been concluded, some have not. And weirdly, again, they are almost all similar, or you will find the nuances rhyming with other jurisdictions. I think South Africa already has one for poultry. We also have one for poultry. You have one for South Africa has had the digital markets. We have the one I mentioned on online delivery of food and groceries. I think that's where we have had the most learning, because I think it's where we've seen the most correlation, or at least a chance to go into the nuances of the digital market. And what we found as we were engaging with the Kenyan authorities is really the motivation to starting this study, which typically is, and it's exactly what is intended by the Act. They were coming from a point of, yes, we can see this is a major player in the market, and we can see this is a major sector of the market. We can see there's a lot of public concern about it, but we don't really understand how it works. There may be what you see on the internet, there may be what people say on the internet, and there may be our interpretations of how that business works. But as we realized, while we sat down with our clients across all the markets inquiries where we've assisted on, is you do realize that there's a very, very big nuance, very big difference between what you see from the customer-facing end or as a stakeholder, and what the gears that are shifting inside the actual business machine are. And I think that was where the greatest challenge came, but in all honesty, probably the greatest joy came from a professional standpoint, is to delve into how that business works and actually explain those small nuances to the competition authority, so that they can understand this is what you see, but this is actually how we've structured it. And we are aware, because thankfully, especially in the online space, you will find that most of the players there will, in as much as they're local, even if they're locally, whether they're global multinational or whether they're local, the globalization of the technology field essentially means that all these business models are kind of modeled upon each other, and they will have just built upon each other in a manner where you will find, say for example, it's food delivery. Every single one will find a way to bring the food to the customer, but how they correlate and how they structure the business and how they correlate between each other as competitors is very nuanced. And that I think that's where the greatest challenge came, to actually explain to the Competition Authority of Kenya, this works, this is where you may have a concern, and this is where you should absolutely have no concern. And so typically we found that this was actually at odds with what the initial, let's say, what the initial thoughts on what they were going to be approaching were. As I said earlier on, before they were approaching it from an abuse of buyer power perspective. At the end of it, essentially, what we noticed ourselves, and I think the authority, once they released their findings, is really these markets are very contestable. The customers have insufficient bargaining position, really. The concept of multi-homing, where different riders, because different riders are, say, for example, in different platforms, they can move easily, switching in between, and that really depends on, that also applies on taxi hailing and that kind of business, and a lot of other digital players. But I think really the concern that comes from this kind of market inquiries, and it's what Angie has also touched on, is there's the hazard of ex-ante interventions being modeled upon something which is quite transitory in nature. Say, as I think Jacob, I think when you're answering the first question, some of these issues are not structural. It might be something which currently appears. It might actually just be because of a regulation which has been introduced in law, or it actually might be just be the nuances of the Kenyan market. Because I think it's the Safaricom CEO long ago who said Kenyans are very peculiar customers, and trust me, you see that in everything that we say. We complain a lot, and we're very peculiar customers, and that was very apparent because one of the things that became apparent over time is, whereas the authority may be seeking to intervene on certain elements, what we had to explain is that you will find with most of these platforms or with most of these digital players, they are essentially a pass-through mechanism. They're basically a connector between different players, and the typical provisions of the law will be based upon elements. I'll give the example of at least the abyss of buyer power concept. Abyss of buyer power essentially foresees the existence of a buyer and a customer. But really, if you think about it, in most of the platforms, the platform is neither a buyer nor a customer. They are simply a connector. They're an intermediary to ensure that you, on this side, see the person on the other side and engage in a transaction and essentially get a fee for facilitating that mechanism. And the law has never envisioned that. And unfortunately, or fortunately, depends on where you lie, there will be attempted interventions which may not see the full spectrum of that. And I think, again, that's why market inquiries, amazing toolkit to be able to unlock this kind of understanding of how the market works. But I think even before interventions happen, there needs to be that nuance about understanding the contestability of those markets, and also how various interconnected regulatory regimes come in. And just to close off, I think what another thing which has become very apparent, at least in the digital space in Kenya, is that well, we got out Data Protection Act in 2019, but as I said earlier on, the Competition Authority of Kenya had already started focusing on data protection in the competition space even prior to that, which I think was quite a pioneering move on their part. But as we've gone through these market inquiries, which have related to the digital space, there's been a very express notion from them that we need to focus on who's collecting this data, what do they do with this data, if this person has a bulk of it as compared to their competitors, and how exactly do we treat that. And also through our conversations, they had the awareness to actually confess, are we actually the person who in the right place to do this, given that there's another regulator in the space, given that there's an Office of Data Protection Commissioner. But there's also, given in Kenya, we have, they also have a consumer protection mandate, where now it becomes a question of, given that these, again, the platforms are not necessarily a buyer nor a customer, are our laws currently crafted in a manner that is actually adequate to actually capture their role in that space? And so those are kind of nuances that we have noticed. But again, we are still waiting to see how focused the results of this market inquiry will be, and give us some interpretations of how to approach the law on this. And hopefully interventions, if they come, ones which are practical and actually implementable and not inconducive to business.
Thanks, Matugi. That leads us very nicely, I think, into the discussion that Jad's going to have about our experience in South Africa with market inquiries.
So in the context of South Africa, what we've seen is this online intermediations platform market inquiry that I mentioned earlier, and which Angie has already spoken about briefly. This market inquiry has essentially been, to summarize it, it's not enough just to teach someone to fish. You need to ask who owns the pond, and who are the biggest crocodiles in that pond. And the commissions approached it in that way. As a starting point, they identified who were perceived to be leading platforms. That list was ultimately whittled down to some degree. And the standard of analysis followed in a market inquiry in South Africa is, are there features of a market which the Commission believes restrict, distort, or impede competition? And in addition to that, one of the factors which the Commission must consider, which is a central theme of our Competition Act, is how market conduct would affect the ability of small to medium-sized enterprises or historically disadvantaged persons to participate in markets. It is important to note as well in the South African context as in other jurisdictions, these market inquiry provisions exist independently of other behavioral type provisions in acts. So there is no reason why any authority can't launch an abuse of dominance investigation, for example, in addition to conducting a market inquiry. And that's what we've seen in Europe in many cases. The other thing that's important to bear in mind is that the standard of analysis that the Commission needs to conduct in a market inquiry is different to that in a prohibited practice inquiry or indeed in a merger inquiry, where you're looking at, does this particular event or conduct, does it substantially lessen or prevent competition? And if it does, are there any justifications for that particular event or conduct? In a market inquiry, as I mentioned, you're looking at, are there features of a market which may harm competition? And if there are, how do you remedy those adverse effects? And in looking at these markets, the Commission has sought to remedy those anti-competitive effects that the Commission has identified. Those effects have been quite interesting in the way the Commission's framed them, and the remedies that the Commission has formulated are certainly quite novel. They're also novel in the context of trying to regulate activities of major global tech companies, which may raise questions of jurisdiction and efficacy of enforcement, which is something which our courts in South Africa are already seized with in the context of a forex cartel. So in looking at these types of remedies that have been imposed, they are far-reaching. And what is also interesting is that they have required spend commitments of global platforms which may not have a presence in South Africa. So when you look at the types of remedies that have been imposed, there are remedies that are competition-focused, that will relate to self-preferencing, to parity clauses, to anti-steering in the case of app stores. But when you look at remedies that have been imposed that are not competition remedies, that function within the public interest space, well, those clearly express an intention by the Commission to self-preference, and that is self-preferencing South Africa. So when you have a look at remedies that were imposed on Google, for example, those relate to quite hefty spend commitments. So there's a spend commitment that's required of about $17 million, and that's to help South African-owned businesses that are small to medium-sized enterprises or owned by HDPs to participate in markets. And in addition, in the App Store space, I mean, there is an obligation to give free ad credits to South African app developers of about $9 million. Then you've got Takealot. So Takealot is South Africa's answer to Amazon. And essentially there are initiatives that have been imposed on Takealot, which require Takealot to promote historically disadvantaged persons on their marketplace. What's also quite interesting is the Commission has sought to regulate in advance. And that is in the case of Amazon, which is entering South Africa. And the Commission's expectation is that Amazon has to abide by the same principles that Takealot needs to abide by. Then you have a look at a firm like Booking.com, obligations on Booking.com, in addition to competition type remedies, are to identify, onboard, and promote establishments and activities that are conducted by small to medium-sized enterprises or firms owned or controlled by historically disadvantaged persons. Apple, likewise, has had similar requirements imposed on it as Google in the App Store space. And those also relate to the promotion of South African historically disadvantaged developers on the App Store space. The remedies relate to curation and are also quite interesting. But at the same time, what needs to be appreciated there is that these are particularly far-reaching commitments and far-reaching remedies that are expected of these firms. And especially when you are considering spend commitments and changes to ecosystems, it's something which needs to be looked at carefully. And that's particularly in the context where these are rapid and dynamic markets, where what happens today might not be relevant tomorrow. And in circumstances where you still need to encourage investment and innovation in markets. In addition, there is still a requirement to link what you perceive to be an adverse effect on competition to actual evidence that's being gathered. The Commission's position is that in a market inquiry, the standard of analysis is different, so you don't necessarily need to define markets with the same vigor as you would in, let's say, a merger investigation. And that may lead to different outcomes, which are not necessarily desirable, but obviously, in the case of these novel remedies, are untested. What has happened, though, I mean, which will also be interesting to see how it plays out, is that a number of firms on which these remedial actions have been imposed have sought to challenge the Commission. And that's either before our competition tribunal or other avenues before the traditional non-competition courts. But those cases are in their infancy, and we ultimately do not know what the outcome is going to be for these firms and for the individuals whose remedies have been imposed for the benefit of those individuals.
Thanks, Dad. Jacob, does this mean we're moving away from traditional ways of defining markets and measuring and identifying dominance and market power?
Yes, I think that's certainly been the approach that's been taken in the market inquiries. Before I touch on that, though, I just wanted to say I think my fellow panel members have set out what are some of the pros and cons of using market inquiries more extensively to investigate firm conduct. But what I would say is that I think that the potential pitfalls of market inquiries are particularly prevalent in these digital markets. So when we're talking about a process in which the standard of proof, the impediment to competition that needs to be shown, the level of analysis is lower, and where you've got a highly innovative market and you have forward-looking analyses, as Angie pointed out, I think another way of kind of describing those analyses is simply speculative. And you really risk over-intervention in these markets without fully understanding exactly what the implications of intervention will be. Turning back to the question on market definition and market power, I think here again you see the difficulties with applying a lower standard of analysis or proof in looking at these issues, because I think the concern is often driven largely by the idea that these are simply concentrated markets and that they are potential gatekeepers. But in digital markets in particular, you have issues around properly identifying the full range and the strength of the competitive constraints acting on firms, and that requires a very in-depth analysis. Indirect network effects can lead to market tipping, but they can also increase the strength of the competitive constraint acting on firms by working in reverse. Multi-homing can significantly reduce barriers to entry and increase customer switching, and therefore the strength of the competitive constraints that even a small number of firms would face in a market. And you also need to think about competition arising from adjacent markets. So I think here you can again see why taking a kind of a superficial approach to market definition can lead to intervention where that might not be warranted. Equally, I think market inquiries look at a wide range of conduct, and I think that can be problematic when you're dealing with these novel theories of harm, where there aren't established frameworks or benchmarks against which to assess it. Self-preferencing has potential adverse effects on the participation of businesses that use platforms, but that same conduct is often driven by a desire to make that platform more attractive to customers, and so to increase those opportunities for business users to reach those customers. Similarly, pricing has been a particular interest of the Commission in digital markets, and there you have issues around indirect network effects that generate externalities which affect price differentials between customers, but quantifying those can be very difficult, and it requires quite an in-depth analysis. Equally, you have issues where you have high pricing on one side, potentially to business users, and low pricing on the other side, and the Commission is often in these cases trying to find some sort of Goldilocks price. That can be difficult to find in any market, but I think it's particularly difficult to identify in digital platform markets. And so just to wrap up, I think a tendency that the Commission or that authorities in general have in these markets is to try and intervene and directly impact on the conduct itself. But I think a more appropriate way about going about regulation in these markets is by trying to address the issues that might affect contestability. So ensuring that there's an effective competitive process will ensure that outcomes are beneficial to businesses and to consumers, and avoid some of the unintended consequences that have been mentioned so far on this panel of trying to tweak business models directly.
Thanks, Jacob. We're running a little bit short of time, and I don't want to lose the opportunity to talk about convergence. It is, of course, the theme of our conference today. Wangeshi, it seems like there is some convergence in approach between African authorities. Do you see this as a positive development for business, or are there some challenges involved?
As I answer this question, I want to borrow from our chief guest some of the comments that he made. And while we're addressing the matter of whether convergence is positive or not, we need to ask ourselves, does it make business easier, and is it practical? If we are to unlock, for demonstrative purposes, the 1585 percentage that he used, if we are to unlock the 85% business opportunity within Africa, certainly there are some things that we need to do in the competition space, and indeed convergence is one of them. So quickly, the process of convergence means that we want to harmonize the various regulatory frameworks in the various African countries and the different jurisdictions, just to create a consistent, efficient, cost-conscious and regulation. So competition regulation in its own nature should be one that allows, that is far-looking more than just the jurisdictional borders that it is within. It should look outside, and therefore there is space for harmonization of competition regulatory frameworks at national, regional, and continental levels. Now, even as we're talking about convergence, we need to be very sensitive to, the pride that each of the jurisdictions have in their own national regulation. There is also pride in the regional regulations that are there, and there's also going to be a lot of pride when we come to the continental level. So being at that conscious level means that there is space for each one of them. Now, when we talk about convergence, we know that it's going to affect both market conduct and market structure. Now, these are two very intimate things when we look at the different jurisdictions, because then one would have to, is being looked at from a continental level, what you're doing at a local level. So how are you behaving in a particular market? How are you showing up? How is your business structured in a particular market? So it will be looked at a higher level, and perhaps maybe the standards that we shall be held at are quite high. So even as we walk towards our journey of convergence, there are definitely advantages to doing this. And this is what would be our clarion call as we look towards our step towards convergence. And one is the harmonization of regulations tend to streamline border activities and allowing businesses to tap into larger and more diverse markets. There's nothing worse than having a jurisdiction that says A, and when you try to cross the border, it's at Z. So in between, you cannot do anything. So when we talk about convergence, we are talking about allowing businesses to tap into a larger market, make an economy more vibrant. Secondly, streamlined regulatory processes, minimize bureaucratic obstacles, and enhancing operational efficiency. Again, I go back to my first question, where we were talking about the complementary role that two regulators play in terms of looking at the telecommunications industry. Also, convergence would do this for the greater market. Number three, there will be harmonized standards, enforcement mechanisms that offer clearer guidelines. So you will be able to predict what would happen to your business if you went to another jurisdiction. And then there is also the fostering of innovations, exchange of information. You know, data is king right now. So when we are looking at convergence, these are some of the benefits that we will have. So we will have more technological advancements and heightened market competitiveness. Now, back home, our Competition Authority of Kenya, together with the East Africa Community Competition Authority, have already, once again, had an MOU together, because they have also seen the importance of coming together to enhance the competition regulation within this space. And it is really also part of fostering regional integration, so that we're not just speaking about regional integration on certain things, but when it comes to competition, we move apart. So it is more of a harmonious approach. And one of the things that convergence will do is bring enhanced regional integration. Now, when it comes to COMESA and what they're doing, I think COMESA should be commended, because they're fostering cooperation and in terms of looking at what national competition agencies are doing and giving some help, some assistance, and getting into MOUs. COMESA also is going an extra mile to go to countries that perhaps do not have a mature competition regulatory space. We know that sometimes in certain African countries that matters competition are discussed maybe in a small state department, or a small room in a ministry. So they are being brought up to the level where they have a full-blown authority. And this is one of the things that we must look at when we're talking about convergence. We cannot go straight to the convergence conversation when we have gaps, capability gaps of enforcement, competition enforcement within Africa. So this is very important for our conversation as we're looking towards convergence. Now, collaboration is key, like I said, and of course there will be a lot of cohesion and there will be business benefits to everyone. So as I close, I want to talk about the Free Trade Area Protocol and some of the opportunities that it is offering, which is one, the creation of a unified market. And this, what does this do? It will broaden the business opportunities, because everyone is in business. Everyone wants to make, greater strides, get more profit, put their products out there. So a unified market by FTA, this is what will happen. Then when with such positive uptake, there will be economic growth and investment within Africa. Again, I want to enforce what our chief guest said, to unlock the 85% that he used by demonstration. This is one of the things that we need to do. But parting short, once again, let us remember to be sensitive to where competition has started from. It starts from the local level, then it matures onto the regional level, and finally to the continental level. Let us ensure that we take the gains from each of these stages towards an Africa Free Trade Area Protocol. Thank you.
Thanks, Wangeshi. I'm sorry, we were hoping to have time for a few questions, but unfortunately, 5 minutes for questions. Okay, that's excellent. Anybody got any questions, or we'd also welcome some comments. And maybe while you're thinking of those, I'm going to take the opportunity just to ask former Judge Dennis Davis to give us a few comments, because we've recently had a very interesting case in South Africa which talks to jurisdiction, which of course is a key issue in digital markets and potentially a barrier to enforcement of competition law in the digital space by authorities in Africa.
Yes, but I mean, the case I dealt with, of course, is not digital.
No, but forex
but it does have
trading-
implications, yes.
Yes.
I mean, the big problem for any competition authority is, of course, how do you assume jurisdiction? And if you take the standard version, you have to have subject matter and personal jurisdiction. Why? Because you need to enforce the order that could be made, which means even if you take the standard view that Section 3(1) of the South African Competition Act has, which is effectively the same as almost anywhere in the world, namely, does it have an effect? Conduct have an effect? Question is, can you enforce that? Which is where the personal jurisdiction comes in. We developed that. I'm not sure that I desperately don't regret that now, but that's another matter. To say, if you're involved in a business which you could categorize as South African, then it's possible to argue that there is personal jurisdiction, even if you're technically a peregrinus. And so it seems to me, listening to your conversation this morning, Heather, is that in many of these digital cases, that's precisely what the position is. And of course, I might add that the dilemmas that all of you are agonizing about are exactly the same ones that tax authorities have, which is, how do you impose a tax in a digital world where conceptually residence is now the basis of tax? I mean, if you go to a source-based system, it's possible that you can. So it's the same problem. And it does seem to me that the answer must be that if you've got a merger of a kind with digital platform, where quite clearly you can classify this as a South African business of some sort, then I would assume that it would be proper to develop the law to accordingly accommodate the authority. If you can't do that, well, then national authorities are in terrible trouble, which goes to a final point, which is why I think the African Free Trade Agreement and the regional agreements such as COMESA are so important, is because they actually help enormously. And one final point on this is, if you've got an African agreement of competition law, and effectively the authority takes jurisdiction over Google, etc., and Google says, which it possibly can to an individual country, go away, we're not going to be part of your economy, much more difficult when in fact a whole continent bars them from participation. Hence the importance of thinking through regional and continental forms of competition agreements.
Thank you, Judge. And our very strict timekeeper, Gaby, advises me that's it for today. So please join me in extending great thanks to our panel, who are really fantastic. And also thank you, Judge Davis. Thanks very much.
Thank you so much to Heather and our panelists. We have come to the time we need to break for lunch. So we'll break for, how many minutes do we have, Gabby? 15 minutes? 30, okay, great. She's very strict with time, yes. So we're going to break for 30 minutes and then we'll come back for our last panel discussion. Thank you. providing regulatory advice on mergers, and clients have benefited from his wealth of knowledge of the South African merger regime and the inner workings of the South African competition authorities. Amanda provides advice on the competition law implications of activities, including mergers, and in negotiating conditions with competition authorities, as well as behavioral matters, competition compliance audits, competition due diligences, and competition training. Amanda is a specialist in South African competition law and has also advised in respect of merger notifications in both Botswana and COMESA. I'll hand over to Amanda to introduce his panelists and his topic. Thank you.
Thank you, Joyce. Appreciate the introduction, and good afternoon to everyone, and welcome to the third and final panel session for today. It's good to see the room is still full. We really appreciate you guys honoring the invite. The topic for discussion in our panel is the impact of public interest, protectionism, and the expanded political economy on competition regulation in Africa. In many African competition authorities, what we've seen is that they've increasingly put emphasis on public interest consideration in competition regulation, and in particular in merger regulation. Most notably, merger regulation in South Africa and in most other African countries is heavily influenced by the government policy agenda, and thus there has been a growing convergence of competition law and social policy outcomes throughout the continent. Many African merger control regimes have developed a competition policy approach that balances traditional competition law considerations with public interest considerations, especially in terms of market concentration, access to competitive markets for small, medium-sized enterprises and indigenous persons, the greater spread of ownership by firms owned by historically disadvantaged persons as well as workers, and employment considerations. While it should be acknowledged that the imperatives sought to be achieved by public interest considerations are quite important, there has been growing debate on whether competition regulation is the appropriate mechanism to achieve these public good outcomes, or whether such rigorous emphasis on public interest consideration, which may be seen at times as very interventionist, may lead to a chilling of investment in the continent. To help us navigate this important topic, we are joined by a very esteemed panel. The first panel member is the Honorable former Judge Dennis Davis, who is the former Judge President of South Africa's Competition Appeal Court. And then we have Mr. Babatundi Rukera, who is the former Executive Vice Chairman at the Federal Competition and Consumer Protection Commission in Nigeria. We are then joined by Wangombe Kariuki, a senior consultant at Bowman's Kenya, who's also the former DG at the Kenya Competition Authority. Without any further ado, Judge, maybe just to begin with you, should public interest, or is public interest part of competition law, competition regulation from a conceptual lens? Can you maybe share some of your thoughts on that?
Sure, thank you. Firstly, thank you very much for inviting me. I notice we're all former. So it's very comforting that I'm not the only former, meaning, some old fogey who really see now. Your question is a really interesting one. When South Africa introduced its competition law back in '98, and we included a public interest component into the merger provisions in particular, you could argue that the preamble and the objective clause have some of that too, but let me not go there. It was fairly revolutionary. And I remember going, Frederic Genie asking me to address the OECD conference on this point, probably about 20 years ago. And most of the delegates thought we were nuts. What on earth were we thinking? Because of the point that you just make. But it seems to me that almost a quarter of a century later, the entire body of competition law has reached what I suspect you could call an inflection point. So let me just try to explain very briefly what I mean. If you look at traditional competition law, it's always been predicated, well, certainly since Robert Bork emerged out of the Gloman in the 1980s, on the basis of the two welfare theorems. The one being that ultimately your markets should try to achieve what we call the Pareto optimum, and to the extent that it didn't, there'd be some theoretical redistributive mechanism. Those were the two. I mean, of course, I'm simplifying, but essentially that's it. And it's been perfectly clear, generally around the world, that given levels of massive conglomeration of corporations, particularly the large ones, you know, Apple and Microsoft and Google, etc., all of those have essentially focused our attention on whether competition law has a role to play in reducing levels of inequality in the world. And if you're in a developing country like ours, the question really is, well, what is the purpose of competition law? Is it to promote consumer welfare stricto sensu, replicating the two theories, two welfare theorems? Or alternatively, is it the EU model of, as it were, promoting a competitive process? Or does it go further than that and essentially worry about, if you could call it, the democratization of the economy? Now, if you're a country like South Africa, and I'm sticking strictly to South Africa because the people here know far more about the other African countries, including my two panelists, than I do, and South Africans should shut up about talking about anything else other than themselves, because they know, because then they get into dangerous water. The point is, if you look at South Africa, and I'm sure this applies elsewhere in developing countries, the real problem for economies is the inability of vast sections of the population to participate in the economy. So strictly speaking, the public interest concerns were to militate against the restrictive nature of the two welfare theorems, and in a sense embrace, if you wish, a principle of democratization of the economy. Why your question is such an astute one is because there is an extraordinary danger that when you broaden the horizon, you raise two significant problems. One, you make adjudication much more complicated because, to quote Lon Fuller, it has polycentric consequences. You've got to work out various consequences beyond simply saying, has price gone up, has output gone down? And secondly, because there's a danger that you bring in industrial policy into competition law, which creates its own problems. And thirdly, if I could put the third one, which is where the South African situation comes about, is where it promotes forms of rent seeking, which means all of a sudden the merging parties have to dollop out certain amounts, whether by shares or money, in order for the authority to say it's all fine. And that, as it were, is subversive, seems to me, of the fundamental proposition as I've outlined it.
Thank you, Judge. I think that's quite an interesting view and quite provocative, especially the last point that you make. Maybe just to move on to my colleague Wangombe. We've seen a surge in public interest remedies in the continent of late. What do you think is upward trend or elevation of public interest in the continent?
Thank you, Amanda. And not that I've done research on this, it's just anecdotal. And my observation and the history I experienced when I was a regulator. One is that I have to highlight that governments set laws or provisions within law to attend to the problems facing them. And my experience is that the government does not care where the law or the provision is provided, so long as it can attend to a problem in a very fast and short time. I experienced this when I was the regulator 2 times when the COVID-19 pandemic was being declared. Somebody called me from the National Emergency Council and told me that we are going to declare the first case of COVID-19, and the council has decided that they have intelligence prices would rise, and they decided the Competition Commission, or rather Competition Authority of Kenya, is the one which is going to deal with it. So my challenge was, if I told them that I didn't have the powers to deal with that, the government would have gone ahead and placed price controls, which would have been a more egregious infraction into the economic paradigm which we were at that time. And I was told, you'll be caught by so-and-so. I don't want to mention the name, could be the second highest person or the highest person on the land, and you need to explain to them. So I was left to interpret the law purposely. And I had to interpret the law purposely. Lucky enough is that I had the consumer protection provisions where I used some of the price gouging under the consumer protection to attend to that problem which was in existence, because I couldn't allow the government to come up with price controls, because that was sending me home early, because I was supposed to drive the free market economy. Then the other time I experienced such a situation is that we were having retail companies collapsing in Kenya. We had Uchumi, then came Nakumat, but the government was wondering, how do we deal with this situation? And I was told we are coming up with a budget speech and proposals, and the government is seeing, instead of coming a totally new law, is that the Competition Authority, we can see how we can accommodate these provisions we are talking about. And I said it's a bit difficult, it's not a normal consumer competition issue. Then they said, at least you understand it's not a normal consumer competition issue, and we appreciate that. How can you create a provision there which is neither as keen nor the meat, and then you bring it within the Competition Act? And that's why, Joyce, we came up with abuse of dominance provisions, which I had to support. And we're talking about, it relates with the supporting of the SMEs, where there was a very high mortality rate, and it was impacting the supply chain within the economy. And when this supply chain is affected, it affects the whole competition paradigm, and all these sold. And therefore, is that I had to deal with that. Now, that is when I understood that the government will always give a chance for you when it comes to public, promulgation of laws, but there's an engagement where you have to come up with a proper law to attend to the problem you're having. Why have the public interest criteria expanded within Africa? The challenges which came up with COVID-19, that is the global collapse of the supply chains, 2, the ongoing geopolitical tensions, and number 3, the climate vagaries and the concomitant vagaries like food insecurity and lack of basic necessities. Those are the main issues the government is focusing on. And when the government are setting their budget proposals and agenda, is that all the government agencies, including the competition authorities, are supposed to align their activities towards that. As you can see, these are more of macro nature. Regulators, they have now to align their activities to impress the person who supports their budget. To me, is that I call it a regulator's catwalk in terms of who comes with the best design to support these government budgetary interventions. So they have moved from the normal competition regulation, which takes too long to achieve the optimal intervention or the optimal objectives, and come up with this public interest where you are trying to salvage jobs, and also how you are tending to the food security. So that is where you have seen the competition agencies focusing on that. The other thing is that also they are focusing on that to help them bid for their resources to continue their sustainability. But all this depends with the overzealousness of the leader, both at the authority, or two, at the policy level, or three, at the topmost of the government in terms of how you implement those public interests. Those are my observations.
Thanks, Wangobe. I think I'll come to that point in the second round, the last point you made. I think it's a very interesting point that you make. Maybe Babatunde, let me come to you. So in previous engagements, we understand that one of the key areas of focus in Nigeria is the protection of indigenous businesses, right? So my question to you is, how does the regulator sort of navigate this objective while still trying to encourage foreign investment in Nigeria?
Well, good afternoon. Thank you very much, Bowmans, for inviting me, and Amanda, thank you for moderating this. And my gratitude is only halfway because you already put me in the middle of this format. Judge Davis is also wrong to imagine that all three of us are just farmers. In Nigeria, there is a progressive trajectory. It's usually first immediate past, and then you become farmer, then you become X, and then at one point you become one time. And so I am the least mature here, and Nigerian competition regulation is the least mature. So please expect the least insight. But yeah, and thanks for the question. And I think in a manner of speaking, Judge Davies and my friend Francis have addressed some of the key points that really thread through exactly the same thing. And so, for instance, national priorities would always take precedence. The government institutions, wherever in the world, would always look at their role through what really is a themed or superior central national priority. Nigeria is no different. For instance, the constitution in Nigeria specifically makes provisions about competition. It says that all the organs of government, whether it's the legislature, the executive, or the judiciary, will exercise all their powers constitutionally to ensure that the means of production and wealth is not in the hands of a few or a few groups. Essentially democratizes access. And put in just one word, the Constitution is set up to promote shared prosperity. And just like Judge Davies said, one of the fundamentals of competition regulation is that exactly right. Consumer welfare, and the consumers getting the best, and a key ancillary to unlocking the markets for the benefit of consumers is that other businesses benefit. And so, in Nigeria, at the last count by the World Bank, had come down from 40 million small and medium scale businesses to about 36 million. That's an attrition that's not good in a country where the informal sector is actually larger than the formal, and the small and medium scale businesses pay more taxes and employ more people. And so for a country that wants to be inclusive, there is no way a competition regulation will not have this catwalk, like Francis said, of trying to balance what are the real interests here. And with a history of extremely concentrated markets in all the things that are extremely important to citizens, and the concentration in the market typically dominated by big and many times multinationals. And so even with the best of intention and effort, it is not unlikely that there could be a perception that there are some elements of protectionism. But what we did in the agency when I was there was to capture all of this and to look at it from a larger standpoint of attempting to unlock existing barriers instead of preventing transactions from moving on. And if the market did not correct itself after unlocking the barriers, then you go back to the toolbox. And while, I mean, activist, bar and competition practitioner side, you say, we will not know that you're not a rubber stamp until you block a transaction. You know, I'm sure we all experienced that. But what we did was we still remained methodical and looked at some of the key elements and sometimes even assisted parties with having them suggest remedies to us that we thought could work. So to the extent that you can see the competition regulator as potentially pursuing a protectionist agenda, in reality, if you put that in the bucket of what are the national priorities of the country, all you would see is a regulator pursuing either the administrations or the overall national priorities of the country. And it is not without benefit. It's not without benefit. And so one thing that we did in the FCCP side, and I personally came up with this as language in the regulatory environment and also to businesses, that this market, at the end of the day, the most important role of government is this protect and promote the welfare of these 220 million people. And that's not just territorial or from insurgency or territorial aggression. The welfare is really about the market, their businesses, their access, how much they're buying things, and their opportunity to participate in the economy. And so I always said that, look, let's look at it from this standpoint. This is the greatest asset the country has, this number of its people in that market, and that market is open to be explored, not to be exploited. And so we'll look through that prism and say, what are the real benefits here? Because it is quite possible that you see that even a foreign business, a large business, ultimately even provides more benefit, both from a consumer standpoint, from an employment, technology transfer, the buzzwords for public interest. And so we'd say that that's exploring the market. But when ultimately the conduct of a business, whether foreign or domestic, really puts nothing in the ground and just takes what it can take, even though it is acting legally, that's, and whether you're exploiting a mineral asset or exploring it, none is illegal, but one is more expedient than the other. And so we decided to choose and pursue based from the expedience. If that turns out to look like protectionism, we took it as a mere coincidence. Thank you.
Thanks, Babatunde. I won't say whether it's protectionism or not. I think the audience will form their own views on that. Judge, I think you mentioned quite an interesting point in your opening remarks about how do we adjudicate public interest, particularly in an instance where we also have competition factors to look at. I think you presided over one of the landmark cases in South Africa that dealt with public interest. Maybe can you just take us through how do you balance competition and public interest considerations from an adjudicative perspective?
It's a really interesting question, and I think the case, of course, you're talking about is the Walmart case. So just for people who don't know, of course, Walmart decided they wanted to enter into Africa. They found a company called Massmart, which basically did pretty much the same in a smaller way in Africa, and they acquired 51% of Massmart, and effectively this then gave rise to competition investigation, and ultimately the matter came to us. Of course, the first question you always ask in a merger, which is the traditional one, of course, is whether there were any cognizable competition concerns. And the one thing you knew about Walmart was that they brag that they have cheaper goods and more accessible than anyone else. A friend of mine, who at one point I thought was the best competition advocate in the country, but then retired, told me, he lives up the west coast of South Africa, that he had they had a little grocery store, and all of a sudden it was taken over by Spar. And I should not worry about the small little store as such, because the owner was rude, charged high prices, and when it was taken over by Spar, there was a courtesy and the prices went down, everything was better. And of course, you know, that point stuck with me in the sense that obviously Walmart were not going to ensure that pricing went up. The question, which is of course what you're asking, is that there were public interest concerns. There were two. I'll leave aside the employment one for the moment, but ultimately in relation to employment, the jurisprudence said, if you fire people, not in the ordinary kind of retrenchment process which we're conversant with in relation to labor law, but because you want to make nice to the acquirer, you may have a competition concern under the public interest, and there has to be some remedy, and the remedy was that you had to reinstate those workers. The real key question was, to what extent did the Walmart merger, given its value chain, global value chain, to what extent would it impact upon small and indigenous businesses in South Africa? And to what extent, therefore, if you had the merger, would the other supermarket chains in South Africa, Pay, Shoprite, Checkers, Spar, would they be forced, as it were, to jettison small South African suppliers because they could get cheaper product elsewhere? And you know, you learn amazing things when you're a judge, which are completely irrelevant, except in the case, and maybe not there. So I learned that the cheapest place that you could get spaghetti, I wonder whether anybody could tell me in this room, which is the cheapest country whereby you could acquire spaghetti? Yes? Sorry? No, it's Madagascar. Right? Madagascar. That was what we were told. So the question was, if you had a small South African supplier of spaghetti, if Walmart were bringing the spaghetti into South Africa at say 10 or 20% lower, would that force the other supermarkets to do the same? And that raised, in relation to your point, two profound questions. The first is, does that have a competition component? Leave aside public interest for the moment. Meaning, to what extent, if you could weigh up the wiping out of the small businesses, and could you balance that against the lower prices that people were getting for their goods? So to give you an example that was debated in the case, if, for example, you had poor people who required to buy a white shirt for their little boy to go to school, and assuming the white shirt at the cheapest at Mr. Price or Ackerman's was 100, and Walmart were offering it at 80, that's a very significant increase in the welfare of poor people. If you then, could you then ask yourself, to what extent would the wiping out of, let us say, small businesses in South Africa exceed, that loss exceed the benefit of that lower price? Because if that was the case, you could then argue that you had to prohibit the merger. And interestingly enough, the economist who then argued for the commission, which is perhaps deeply ironic given where he is at the moment, James Hodge, right? he tried to do precisely that. He produced evidence to suggest to us that the loss was greater than the benefit. But actually, it didn't really work. And eventually, just to end that story, we then came to the view that on basic traditional competition grounds, you had to allow the merger. Then the question arose, what about the public interest concern? It's still a concern. Not enough to prohibit the merger, but certainly enough to have a remedy. And so what we did, well, what had happened in the case was counsel for Walmart, it was David Unterholz, who was at that stage the most distinguished of our members of the competition bar. He sort of got up before the tribunal, offered 100 million. And the competition sort of tribunal jumped at this, and I remember saying, what's the 100 million for, other than a bribe? And of course, no one could answer. So what we did was we said, we'd like to know whether in fact we could actually get a remedy. And we then invited each party to have their own economist. Now that was controversial for this reason. We were in appellate court, and strictly we should have referred it back to the tribunal. But I'd had the experience previously in an excessive pricing case of Mittal of doing that, and it didn't go anywhere, and I wasn't going to take the chance again. So we invited each side, and it was a strange group of people. The unions had James Hodge. Walmart had Mike Morris, Professor Michael Morris, who for many years, who's a world expert in global value chains, but was a trade unionist and had been detained for almost a year by the apartheid government for his trade union activity and was really on the left. And the minister chose the ex-World Bank chief economist, Joseph Stiglitz, a strange kind of brew of people. And they finally came up with a view. Morris came up with one, Stiglitz and Hodge. We accepted Morris's, which was effectively say, you got to put 250 million rand into a fund managed independently for the purposes of integrating small businesses. Did that work? I don't know, for two reasons. One is because after all the agonizing about this, actually the Walmart merger didn't work. Right? If you think about it, which is you spend all this time worrying about it, and actually Walmart really didn't actually make any imprint on the South African supermarket, which we should have realized because of the nature of the South African. But nonetheless, but I remember coming home one night and listening to one of these financial programs, and a young man was being interviewed by the interviewer about his biscuit factory. And he explained that he had applied for money from Walmart fund for small confectionery business that he sort of had started. He got a grant from Walmart, and now he was employing 25 people. And I thought to myself, these things can work. What can't work in answer to things, and I asked Joseph Stiglitz, it's a funny thing, Nobel Prize winners don't give you any time of day, but if they appear in your court, they treat you with great respect. So afterwards, he became my big mate. And I asked him, when it was all over, I said, can you tell me, is it possible in economics to balance the loss of the small businesses as opposed to the gains of prices? And he said, we can't do that as economists. And so effectively, to answer your question, what the Walmart case showed was that you need to demarcate between, if I could call it, generally cognizable competition concerns, which may well include the competitive process and issues of abuse that you spoke about, quite rightly. But when it comes to the strict Section 12A public interest, you should keep that as a separate inquiry, which triggers its own remedies. Unfortunately, if I could finish, it seems to me that what has been happening is sadly the Walmart judgment and the remedies have been used now for all sorts of bargaining of unseemly kind, where the foreign company said, well, you know, if you give us an extra employment share option scheme, not of 5%, but make it 8%, etc., then we'll allow the merger through. That was never our intention. But in concept, what the Walmart merger showed was that the real action is at the remedy stage.
Thank you for that, Judge. Maybe just to move Wangobe. I think you mentioned something about catwalking. Just to pick up on that, do you think there's a danger here of national competition regulators being used as a tool by national governments to achieve protectionism or other government objectives that are outside of competition policy?
I don't know how to answer that, because as I started, I said that governments, they don't care who is implementing which law. It's which person is the easiest to implement the law. And I don't want to start as I'm not a motivational speaker, but what I would like to say is that the relationship between regulators and government, it's like the relationship in your household. In terms of you can decide to be aggressive in your household to your partner, or you can decide to be assertive, or you can decide to be submissive. And out of these three, I think assertiveness is better for both of you rather than the aggressiveness and submissiveness. What I've realized, what I realized and what I'm realizing in terms of the institutional governance now, I'm seeing degradation of institutional capacity for governance. I don't know whether it's because of the Trumpism effect permeating across the whole world, where the power is being concentrated on top by one person. And this degradation of institutional capacity, obviously it's due to submissiveness. And therefore, I don't need to answer your question to say yes or no. But moving
independence,
this situation has been exacerbated further by, political intrusion comes from the appointment process. I've seen not only the appointment process is political, but now even the politicians are the ones who are being appointed. So what does that mean? Is that this person, one, in the first place, they lost an election, they are jobless. So they have to sing the song of the people who appointed them. Number two is that they don't appreciate the issues, and therefore they always push for the agenda of the political appointee. So yes, we are seeing this, and they will continue. Then the other issue is that what I call the Trumpism effect is that we are lacking kind of collegiate decision making, at the board level of the regulators, because they don't have that capacity of competition evaluation. I've had a situation where you take a matter and it has got no substantial lessening of competition. And I've seen it where even recently, one of the competition agencies, a merger which had only 3% market share, was forced to retain 4,500 employees. A public interest should always be inserted when there's serious competition issues. But you can see is that I think the competition agency which did that, maybe it wanted to, in Kenya we say to earn some bonga points, to the people who have appointed them. But I don't want to sound very negative, but also is that I've seen even where there are competition laws some of the body politic or even the ministers are not appreciating the existence of those laws. In Kenya the other day, I heard there was a cartel. One of the ministers said there's a cartel in one of the industries. And when he said there's a cartel in that industry, he did not push for the competition agency to investigate that cartel. They pushed for the importation of that good into the country. The Competition Authority of Kenya, I don't think they raised any issue about that, which I think, and this is what I'm calling about submissiveness. They should have said, hey, we have a competition law, is that we can attend to this problem with this. Then the other issue is that sometimes back, Competition Authority of Kenya, this one, it was in the press, gave an advisory opinion in regard to one of the industries, which is very key to one of the government agenda now, in terms of don't increase import duty for clinker and cement, because one is that it is very key in the development of the affordable housing. Two, it is going to lay to or jeopardize all the other companies, even which are some are listed in the Securities Exchange, to the detriment of the majority of Kenyans. And the government then listened. Then 1 year in the next budget is that what the authority had guided was put under, and what it had opposed has been actualized. And therefore, I don't want to say what the CAK did, but it means they have not taken up that advocacy role, which they have, and they could have raised it to the government. Yes, they can be misused. Two, what is the solution? Is that as the investors, we can go to courts and raise the issues. Also is that we can be part and parcel of this participatory process of promulgating laws. And also is that I've seen situations where the use of the fourth estate in terms of highlighting some of these ramifications to the economy has made the government change. But also most importantly, I'm for an advocate for documenting of competition policy now, which transcends governments rather than just having a law. Because if that minister was aware that there's a government policy in terms of competition policy, is that we will not have gone that route of dealing with, crying wolf and trying to attend to that wolf, and yet the wolf was not there. Thank you.
Thank you, Wangobe, for that. Babatunde, maybe just to link this panel to panel one, which was discussing the ACFTA. Do you think, does weighing up public interest factors too heavily risk engaging in protectionism, which is at odds with fostering competition across African markets, as what's being envisaged by this new protocol that's being debated at the AFCFTA level? What are your thoughts on that?
And that's an excellent point. Excellent point to be discussed on a platform of Bowmans, obviously with the largest competition practice on the continent, and at an honor, and where the theme for this year is towards convergence question. And the reason why I say that is, at the end of the day, we must now ask ourselves whether the arguments that occur between the business side, their representatives, and the regulators or the government side is going to end, or going to, in one way or the other, ultimately provide the regulatory clarity and stability we truly desire. Because I suspect that it would be a self-defeating argument when now what we're arguing is potentially protectionism at national levels and putting the regulators on the defensive. Would we now proceed to arguing protectionism on the continental level? Because very clearly, the most fundamental desire of the Continental Free Trade Agreement is intra-Africa trade. Okay? And it is one of the most prominent things. And even from outside Africa, they say one of Africa's greatest commerce challenges is that it doesn't trade with itself. And so if we are literally creating a continental free trade area and the whole infrastructure to support it, and the basis is to trade with ourselves, by its very nature, inherent is that protectionism or not? And so we've got to go back and consider what those questions are. And it would ultimately show us that the debate won't end, it would only complicate. And so what we have an opportunity for, in my opinion, is instead of the case by case and trying to win in each case and winning on an argument that's going to defeat you when you have the next case, is that we should now start having conversations about what the broad elements of what constitutes acceptable public interest is. Because make no mistake about it, on this continent, thinking about the common man and their access and participation in the economy will always exist. As a matter of fact, not to consider that either at the local government level, state, national, regional, or continental is by far an irresponsibility in governance. And so let's accept what it is, and let's accept that even as competition regulators, ultimately our role is governance. And even as business practitioners, representatives of businesses, what you're contributing in the regulatory process, the engagement with regulators, is streamlining, engaging, sometimes contesting for one purpose, for better governance of all the spaces, whether it's social policy, economic policy, whatever the case may be. And so I think that we're still on the max. We have an incredible opportunity of convergence and some level of standardization, not necessarily to the detail, but at least from the principles and from the broad columns of what those considerations would be. If we don't do that, we could, just by competition policy and regulation, completely defeat the entire purpose of the continental free trade area. And that would be one more failed attempt for a continent that really needs each of those efforts. And so, right now is the time. And the experiences with a firm like this, with offices in different places, the ability to pull regulators, and then immediate past, former ex, perhaps even one time, is the exact thing for a secretariat that is still young, burgeoning, and depending. And so I think our discussion can even move from arguing against, look, at what point this thing is a slippery slope. It will always be a slippery slope. It can only get less slippery or more slippery. And so we can just move to say, what are the acceptable heads? And then we would be driving convergence. From my experience in conversations, it's very clear to me that the biggest factor in intra-Africa trade is going to be market regulation. It seemed like it was going to be customs, duty, and all that. But for some reason, those guys have moved on, right? And I don't know why we thought it was going to be problematic anyway, because regionally, we were already doing something along that, single markets. And so for some reason, they've been able to move on. So it's really the market regulation that is likely to define. And every one of us here is key to that market regulation framework. So I think the argument about what constitutes protectionism across the board in small places will either be broken into what, 54 or 5 or 6, and none of them is a winning argument. It's better we just come to terms on what, and if we put everything in the bucket, if there are things we can agree on, that's what it's ultimately going to be. And so those are my thoughts. I mean, this might be, I told you I have the least insight, so this might be my way of avoiding the question, but it's my contribution anyway.
Thank you for that, Babatunde. Maybe, I do want to open it up to the floor, and I see we have, I think, less than 10 minutes now, Gabby. Can I invite any questions maybe from the floor online? If not, we can continue the discussion. But I think I just want to open it up to the floor in case there are any questions.
Good. Not so much a question, but just an observation, because some outside commentators may look aghast at public interest concerns being used to extort, subvert, persuade merging parties to give remedies. But actually in Europe, we do a bit of this ourselves, okay? We don't call it public interest, but EU law is not, EU competition law is not just about competition in the narrow welfare maximizing sense. It's all about market integration. It's a policy in an instrument that's really about market integration and other policies. And I'll give you 3 examples of where the competition rules and their enforcement have demonstrably been used to pursue other policies. First is the vertical agreements rules that we have in the EU, which go back in their infancy to a judgment of the Court of Justice in 1966, Constant versus Grundig, where the famous distinction between active sales and passive sales was developed. It's a judicial construct to reconcile partial exclusivity of distributors with the need for market integration and not allow absolute territorial protection. Nothing to do with microeconomic consumer welfare maximization. And that policy, that reconciliation of consumer welfare and market integration runs all the way through the vertical agreements rules that we have. You look at the guidelines we have, a lot of the rules in there, the way in which they're applied, are really about market integration, not about consumer welfare in the narrow sense. Second example, environmental policy. We've got the thing called the Green Agenda, big thing in Europe. The Commission's horizontal cooperation guidelines released last year, the most generous guidelines and practice on horizontal cooperation for environmental reasons. Nothing to do with welfare maximization, a completely different policy objective. Thirdly, the state aid rules. We've got a rule that says, and it's in the competition chapter of the treaty, it is competition law. It says you can't give state aid unless it's approved. Blanket prohibition. State aid historically has been a big check from a government to prop up an inefficient and ailing industry or competitor. It can also be a forbearance by the government, not to take a payment that's due. The Commission about 10 years ago tried to use these rules in relation to aggressive tax planning, base erosion and profit shifting. And there was a whole series of cases where the Commission used this article, Article 107, not for state aid in the true sense, but simply because the Commission felt it needed to do its bit with the tools in its toolbox to stop profit shifting. So that's just 3 examples which hopefully make anybody who thinks that the use of public interest factors in a competition review process is bad, maybe make you feel that it's quite not quite so bad or unorthodox.
Yeah, I think you're right, but it shows this, that in law, context matters. And so I can perfectly understand that environmental issues, and I, as a tax lawyer, was particularly fascinated by the use of competition law to deal with those cases. I think that's absolutely correct. And of course, it's rolled into being a different nomenclature, but it's exactly the same. The key issue, however, I think in developing countries, is the point that we've been agonizing about for quite a lot in this panel, which is the way in which you integrate small entrepreneurs and nascent businesses into a competitive process because of the imperative of economic development. And there's no question about it, that if you look at the public interest in its best possible light, then that's what it's really about. It's an attempt, in a different way, but just because of context, to encourage the process of participation in an economy. How could you possibly, in South Africa, have an economy in which only 5 million white people participated? I mean, it's just, you just have to state that to realize just how absurd that proposition is. And so clearly, you're right. I've often been annoyed by the fact that when you get people telling me, but you people are off your rocker, all of the three examples that you mention show that no, it's just a question of, what are the goals in a slightly different context. One of the problems, however, when you think about that is to think through with a level of precision. I take your point about the slippery slope, but to think through the level of precision what your objectives are. Let me give you an example. So I tell my students when I teach them the public interest factors, mergers, and in particular the Competition Commission of South Africa's guidelines, that if one of the objectives is to spread ownership to historically disadvantaged persons, Black South African, what does that mean? If, for example, I've got a merger and I give Patrice Motsepe, the wealthiest man in South Africa, but he happens to be Black, an extra 10%, how on earth does that promote the fundamental objective of public interest, which is to ensure that workers and the impoverished and those who basically continue to get the short straw in South Africa are beneficiaries of what the project is? So you've got to be, what I'm trying to say is I'm with you, but I get very frustrated by the lack of any precision, even if these concepts are more amorphous and ambiguous than simply saying the price goes up and output goes down. We all know what the normative animating idea of all of this is, like you would know the normative animating idea of promoting the environment. And rightly so. Markets should promote, should not blow up the environment. And it's exactly the same. Markets in the developing country need to ensure that the vast majority of people get a fair crack. And if I could put my hat on just as a constitutional lawyer for a moment, if you don't do that, well, then you get the Donald Trumps of this world and a whole bunch of populists to exploit the fact of the impoverishment of the majority and the beneficence of the small rich for all sorts of undemocratic advantage. So I'm totally with you. And I think we need, what you've said is so important in ensuring that we aren't looked as outliers, but in fact are grappling with the fundamental developmental problems which confront the whole world, but in slightly different contexts.
Thank you, Judge. Thanks, Juan.
I was going to add that I think from a principle standpoint, what you've literally done is to validate what the issues are. And so it now comes down to language. And so public interest seems to be something that's almost antithetical because it's social policy and you're using commerce to enforce social policy, which in some sense, market integration also has its basis in some level of social policy. And it reminds me of something a friend of mine once said to me. He said, see, sometimes the differences is just differences in the semantics. And he used a particular example between Nigeria and the United States with respect to lobbying. And he said, well, what we have in the United States is legislative incentivization. But what you have in Nigeria is non-legislated legislative compromise. and so in a manner of speaking, that's what it is.
Thanks for all the input. Gabby, I see we are at 6 minutes past 2, so I think I'll close the panel discussion. Thank you to all my panel members for the wonderful insights. I think it was quite an engaging panel, and I mean, public interest is always going to be at the forefront of our discussion, especially in the continent. So it's always important that we discuss and we revisit these discussions and to see whether we're still on the right path. But certainly thank you for availing yourselves to be part of the panel. And thanks to the audience for staying till the end of our conference. Joyce. Oh, sorry. Please don't want you to panic. I'm going to talk for a few seconds. So if I have your permission, just say one or two words, especially of thanks. And firstly, just to thank our partners and colleagues here in Kenya for the incredible way in which you always host us. Joyce and Paras and the whole team here in Kenya, just your generosity is always incredible. Joyce and I, after the Cape Town conference last year, I reminded her that an agreement, a verbal agreement is an agreement. And that's why we agreed to have this year's conference here in Nairobi. And what a great pleasure it's been. Thank you so much for your generosity. Then I must also just mention the organizing team, Gaby, Angela, the IT teams. I mean, you won't believe the amount of work that goes into something like this and the professionalism. So huge thanks to that group of people. Then the panelists, all of the panelists today. I mean, I think you would all agree, I hope, that the debate has been substantive. It's frank. It's the type of debate that we need to get to the heart of very, very tricky issues. And I think that's one thing about this conference. Over the 12 years that we've had it, we've fostered a comfort, a professionalism to have frank debates around tricky issues and where there might be differing perspectives. I just want to acknowledge the judge, Judge Dennis Davis. You've been a supporter of this conference on many occasions over the years, and we really appreciate it. And I'd like to acknowledge you specifically. And everybody who's traveled a very long way. I mean, I went through the list of countries that have people here today. It's extraordinary that people have come all the way to enjoy this day with us. And we really do appreciate it, and we thank you so much. And then finally, I want to thank my competition partners in the competition practice all over Africa. We work so well as a team, we coordinated, and the most important thing is we focused on our clients. We're client-centric. We cut the balance right, and clients can come to us to get a recognizable service anywhere with the right people on the ground giving the right advice in the context where it's needed. So we really appreciate it. And I just want to mention my co-head in that regard, who's helped put this all together, Tamara Dini. And then I've got something that says parking and tags. I think it's to get your parking ticket validated and to hand in your tags. Is that correct, Joyce? Okay. Thank you. So, and then thank you very much again for everything. And thank you.
Please join us for tea in the foyer. Thanks.
Good job.